Hello friends, in the series on income tax cases today we will discuss an issue which was before the Honorable Madras High Court, and the issue was that if the tribunal remands the matter to the assessing officer and the assessing officer again proposes some variation in the income of the assessee in the transfer pricing issue matter, so whether in the case of remand also the assessing officer has to once again issue the draft assessment order to the assessee before passing the final assessment under section 144C subsection 1. This issue has been decided by Honorable Madras High Court in a decision of a writ petition in the case of Affinity Solar Solutions Private Limited versus Deputy Commissioner of Income Tax. And this case is reported in 487 ITR Act number 133, and the date of the judgment is 24th June 2025. The present case relates to the assessment year 12-13. The assessee is engaged in the business of development and sale of integrated solar installations. During the assessment proceedings, the assessing officer found some transfer pricing issues, so he referred the matter to the transfer pricing officer, who suggested an upward adjustment of 7.03 crore. The assessee took the matter to the DRP, and the DRP suggested an upward addition of rupees 20.67 crore. Accordingly, the assessing officer issued the draft assessment order to the assessee under section 144C subsection 1, and the final assessment order was passed. When the assessment order was passed, the assessee took the matter to the tribunal, and the tribunal remanded the matter back to the assessing officer with the direction to apply the proper method and determine the arm's length price. The tribunal also allowed the assessee to raise all the grounds which the assessee can raise, and the tribunal also remanded the matter with the direction to consider all issues. When the matter was remanded to the assessing officer, then in the second round of litigation also, the assessing officer suggested some variations by referring the matter to the TPO, but this time, before passing the final assessment order second time, the assessing officer did not issue the draft assessment order under section 144C subsection 1, and the final assessment order was passed. The assessee challenged this assessment order in a writ petition before the Honorable Madras High Court with the plea that the assessment order should be quashed in the absence of issuing the draft assessment order under section 144C subsection 1 before passing the final assessment order. When the matter was heard by Honorable Single Judge, the decision was given that the remand was only for applying the appropriate method, so there was no need for the draft assessment order. So the assessee filed the appeal before the Honorable Single Judge order, and when the matter was heard by the double bench, it was decided that whenever the variation will be proposed into the income of the assessee in the transfer pricing issue, then there will be need for the draft assessment order. The court said that remanding the matter would not dispense the requirement of the draft assessment order, and the court said that since in the present case not only the issue of applying the appropriate method was remanded, but the assessee was allowed to raise any other ground in support of its claim, and the assessing officer was to consider all the issues, so it was a complete remand. And the crux of the matter is that whenever any variation will be proposed into the income of the assessee in the transfer pricing matters, then it is requirement of section 144C subsection 1 that again the draft assessment order should be first issued to the assessee for his comments. Friends, this case is very important because it throws light that the procedure in the Income Tax Act are very important. The issuing of the draft assessment order is not a hollow requirement. It is the part of substantial provisions of section 144C that before any variation is proposed, the draft assessment order should be issued to the assessee so that the assessee can be apprised that what variations are going to be proposed into the income of the assessee. So in the present case, the whole assessment was quashed for want of issuing the draft assessment order under section 144C subsection 1. At the end of this video, once again I am repeating the name of the case. The name of the case is Affinity Solar Solutions Private Limited versus Deputy Commissioner of Income Tax, and this case is reported in 487 ITR at page number 133, and the date of the judgment is 24th June 2025. Thank you, friends.